ADA is a civil rights law that prohibits discrimination based on disability. But the road to get there was long and hard. The bill's life began on January 4th, 1981, when the National Council on Disability was formed to examine the incentives and disincentives that existed to allow disabled people to integrate into society. The disappearance of disabled people from public life was the invisible segregation. They found several gaps where the Civil Rights Act failed to protect disabled people. The first draft of the ADA was introduced to the Senate in 1988, and it faced a hard crawl up the Capitol steps. Literally. There were two main groups that opposed the ADA: Christian groups and business interests. Groups such as the Association of Christian Schools International opposed the ADA because the ADA labeled religious institutions as public accommodations. This was all happening at the same time as the Christian right was painting everything as part of a mythical culture war between the homosexuals and the Christians over the government's soul. The Christian right saw the labeling of religious buildings as public accommodations as the first step to the government taking over the churches. You know, the whole persecution complex. They also argued that the government overstepping and ordering religious institutions to make accommodations would be extremely costly and infringe on their religious rights. Apparently, it's a religious right to discriminate against disabled people. Why am I not surprised? But they got what they wanted because religious organizations are exempt from making accommodations. The other group was business interests. The U.S. Chamber of Commerce argued that the cost of the ADA would be enormous and have a disastrous impact on many small businesses struggling to survive. Pro-business conservative commentators joined in opposition, writing that the Americans with Disabilities Act was an expensive headache to millions that would not necessarily improve the lives of disabled people. How unshocking. Capitalism at it again. Businesses were crying once again over having to spend the slightest amount of money to make things more accessible, and how that was a terrible travesty for them, because making the world an accessible place is just too much of a hassle. But their little hissy fit worked, and the undue hardship clause and the readily achievable wording was added. More on what that means later. The final enemy of the ADA was apathy. For a lot of Congresspeople, accessibility was just not seen as a priority, and the bill languished for years until some activists took action. March 12, 1990, disability rights activists gathered at the steps of the U.S. Capitol. They dropped their canes, walkers, and crutches. They climbed out of their wheelchairs and power chairs, and they crawled up the 100 steps without warning, yelling "ADA now" and "Vote now." The sight of over 1,000 people slowly dragging themselves up the stairs was enough to kick Congress back in gear. It received bipartisan support after the demonstration. It was impossible to stand against the ADA and still appear like a good person to the public. Direct action gets the goods! The final version of the bill was signed into law on July 26, 1990 by President George H.W. Bush.
Let the shameful wall of exclusion finally come tumbling down.
And now some legal jargon!
Title I. Employment. This section protects disabled people in job application procedures, hiring, advancement, and discharge of employees, job training, and other terms, conditions, and privileges of employment. And all medical information must be kept confidential. Employers are required to provide reasonable accommodations to job applicants and employees with disabilities. Reasonable accommodations are any accommodations that are not an undue hardship on the employer. Title II: Public Entities and Public Transportation. Title II prohibits disability discrimination by all public entities at the local level, such as school district, municipal, city, or county, and at the state level. Access includes physical access and programmatic access that might be obstructed by discriminatory policies or public transportation, defined as scheduled provision of paratransit services by public entities that provide fixed route services be accessible. Title III: Public Accommodations and Commercial Facilities. Under Title III, no individual may be discriminated against on the basis of disability with regards to the full and equal enjoyment of the goods, services, facilities, or accommodations of any place of public accommodation by any person who owns, leases, or operates a place of public accommodation. The standard is whether removing barriers, typically defined as bringing a condition into compliance with the ADAAG, is readily achievable, defined as easily accomplished without much difficulty or expense. Thus, what is readily achievable for one business might not be readily achievable for another business. Title III has measures to protect service animals and businesses against damages caused by the animal. ADA says that a public accommodation shall take those steps that may be necessary to ensure that no individual with a disability is excluded, denied services, segregated, or otherwise treated differently than other individuals because of the absence of auxiliary aids and services. Title IV: Telecommunications. This section requires that all telecommunication companies in the U.S. take steps to ensure functionally equivalent services for consumers with disabilities, notably those who are deaf or hard of hearing and those with speech impairments. This led to the creation of telecommunications relay services, which change voices to text and vice versa. Title V: Miscellaneous Provisions. The prohibition against retaliation or coercion, such as threats, intimidation, or interference, applies broadly to any individual or entity that seeks to prevent an individual from exercising their rights or to retaliate against them for exercising their rights. This section also grandfathers in Section 504, which was an earlier act that was passed that protects disabled people against discrimination in any program that receives federal funding. Court battles and amendments. When the ADA was passed, it was nowhere near perfect, and it has faced several legal battles and has been amended several times. In Olmstead v. LC, the Supreme Court decided under Title II of the ADA that mental illness is a form of disability and therefore covered under the ADA, and that unjustified institutional isolation of a person with a disability is a form of discrimination. But that's right, until 1999, mental disabilities were not protected. In Green v. State of California, the courts decided that the employee had to prove he was discriminated against instead of the employer proving that they did not discriminate in the first place in relation to Title I protections. This decision significantly weakened the ADA. On September 25, 2008, President George W. Bush signed the ADA Amendments Act of 2008, or the ADAA, into law. The amendment broadened the definition of disability, thereby extending the ADA's protections to a greater number of people by overturning the restriction that an impairment that substantially limits one major life activity must also limit other people to be considered a disability, which is all kinds of fucked up. Unless you were a burden to other people, you weren't considered disabled. The ADA also added to the ADA examples of major life activities, which until this point have been left up to individual interpretation, as caring for oneself, performing manual tasks, seeing, hearing, eating, sleeping, walking, standing, lifting, bending, speaking, breathing, learning, reading, concentrating, thinking, communicating, and working, as well as the operation of several specified major bodily functions. Also expanded the ADA to include protection in employment. Further amendments to the ADAA went into effect in 2010 and focused on swimming pools. Prior to then, swimming pools were not counted as public entities and therefore did not have to provide accommodations, because no disabled person ever wanted to go swimming before 2010.
If you having girl problems, I feel bad for you, son. I got 99 problems, but a bitch ain't one.
So if we have this great act that legally requires accessibility, why isn't accessibility and ableism still a problem? Well, I would say the number one problem is that disabled people aren't seen as people. So organizing is hard, and there are the loopholes. I mean, even if we could organize, the damn elevators for the subway are always breaking, so sure sucks to be anyone with mobility issues. Oh wait, that's me. Haha. Another problem is that at-will employment laws place the onus of proving discrimination on the employee. At-will employment laws are a whole other video. But simply put, it guarantees an employer's ability to dismiss an employee for any reason and without warning, as long as the reason is not illegal. We have no real protection as long as at-will employment laws are in place, and the employer can just say undue hardship. They could say they fired the person because they were late or bad with customers, or did not perform efficiently, and then you have to prove that all of that isn't true. And a lot of companies keep files on their employees of the smallest infraction, so they have documentation to show that you were a terrible employee if they get dragged to court. Another problem is that people don't understand what accessibility really means. They think having a ramp is enough, but having a ramp isn't enough if I don't have enough room to turn my wheelchair around to get on the ramp. So many companies and public entities follow the letter of the law, but not the spirit of the law. They and the ADA guidelines just don't go far enough to guarantee real accessibility. Now it's time to talk about the undue hardship clause. This clause was added because business lobbyists drummed up a lot of concern over how costly accessibility would be for small business owners. The undue hardship clause states that if an accommodation would cause undue hardship due to difficulty or expense, then the accommodation is unreasonable, and the employer or company does not need to provide accommodations. The wording was left deliberately vague and attempts to tighten up what counts as unreasonable accommodations by disability activists have been fought tooth and nail by business interests. This way, it's hard to pin down any ADA violations on companies, and disabled people are shit out of luck. Another clause that makes it difficult to achieve accessibility is the readily achievable standard, Readily achievable is a standard that the government uses to decide whether specific businesses and public entities can achieve accessibility without too much expense or difficulty. It's meant to be a test between the cost to fix things and the resources the business has. Thus, what might be readily achievable for a sophisticated and financially capable corporation might not be readily achievable for a small or local business. But once again, too much expense or difficulty are nebulous terms left to individual interpretation of those enforcing the rules. This causes huge disparities in accessibility. A richer business may be amazingly accessible, while the next door business has narrow aisles and stairs. An easy fix would be to make all physical barriers illegal and have the government fund the renovations. But I guess that's just not worth the government's time. Another huge oversight is that websites don't count under the ADA. With more and more people living lives online, that harms people with reading disabilities like dyslexia or dyscalculia, vision problems, ADHD, etc. It blocks them from accessing online sites because websites aren't counted as public spaces. But the internet is important for everyday life. It might not have been in 1990 when the ADA was first passed, but it is now. Another problem is that because of fear of legal repercussions, some employers just don't hire people with disabilities. It works like this. A disabled person goes in for a job interview, and it seems to be going well, until accommodations are brought up and things get awkward. They say, "Oh, well, thanks for coming in," and the interview ends. Some of my disabled friends won't bring their mobility aids or other assistive devices to interviews and ask for accommodations after they get the job, which creates a whole other problem because then they get scheduled less and less until they're working only a few hours a week, and without any bills that require that employers keep people on a consistent schedule, hour slashing is perfectly legal. But the fear of legal repercussions seems silly when you look at the number of people who actually sue. Hint, it's very small. When the ADA was being written, there were a lot of concerns that disabled people might just not work and instead start suing businesses at random for the smallest infraction. To negate these fears of the derisively called professional plaintiffs, disincentives from suing were placed directly into the ADA. Disabled plaintiffs who sue under the law can't receive financial compensation and have to pay their attorney fees, while the attorneys make money from suing the companies. Suing someone is a long and lengthy process, and without financial compensation, people are less likely to bring a case forward because they can't afford it. So, here's the dirty secret of the ADA. It isn't exactly enforced. That's a big problem. It relies on individual disabled people to follow lawsuits, which take a lot of work and effort. There are organizations out there to help disabled people file lawsuits, but it's still a long, hard fight. Also, because of the myth of the lazy disabled person taking advantage of the system, or the idea that disabled people are burdens, strong advocacy is increasingly stigmatized. Accessibility complaints and lawsuits are often portrayed as greedy, unfair, or dishonest. Disabled people should just shut up and be happy that they even got to live. This stigma has inspired successive efforts in Congress to require even more advance notice and waiting periods for businesses that have not yet made the necessary accessibility changes. There's a word for disabled people who file these lawsuits called professional plaintiffs. And if someone files too often, they can be banned from filing again. Too often is once again a nebulous legal term that is left to interpretation by individual judges.
Well,
I can think of several businesses that I can sue for inaccessibility just a block away from me, and it wouldn't even make a dent because it's a case-by-case basis. Without stronger legislation, it would take a shit ton of lawsuits to make a difference. And people who file ADA lawsuits are already demonized by the media and government. Those pesky professional plaintiffs. Businesses with barriers today mostly seem to ignore the problem, either out of indifference or because they know they don't really need to change. Without any bite to the law, businesses are not going to change. Public accommodations neglect accessibility because they believe that they can. While real enforcement does happen, it is rare and scattered enough that most owners and managers think they won't be punished for leaving barriers in place. There's no real enforcement unless it's on small individual actions, and it has successfully been weakened several times in the court. So to recap, the ADA was a good first step, but it is full of loopholes and vague wording that requires individuals to sue for their rights in order to enforce the law. But at the same time, the ADA has disincentives in place to stop the mythical, lazy, disabled person from taking advantage of the system. But that, in actuality, just makes it harder for disabled people to sue for their rights. The ADA weakens the very mechanism that was made to enforce it, leaving it with almost no power or bite unless individuals actually care to make things accessible. And most times they don't. Maybe it's time for a new plan. I was stuck in bed and you were stuck here with me. But now you may go and live your lives. Go, be cute, keep gay, be crime.